Yes.
Indeed, Your Lordships. Greetings to the bench. Council seeks permission to refer to the benches, Your Lordships.
Okay.
Much obliged, Your Lordships. In this matter, before the Honorable Supreme Court of Virginia, I am Speaker number 1, and I represent the applicants, which include the Food Research Laboratory and the consumers in the present matter. I will be submitting our arguments on the first issue, which is covered through pages 1 of the 7th.
Wait a minute. How can you represent two diverse? They're both applicants.
Indeed, Your Lordships. It's in accordance.
How does that happen?
In accordance to clarification number 1 that we received, this current case is a club petition of several civil cases that have come before the Supreme Court.
How can you represent two diverse clients?
Your Lordships, we represent the same interest, which is that a larger interest of public health and safety.
Go on.
Indeed, Your Lordships. In this matter, I am Speaker number 1, and I represent the arguments for the first issue, which is on the disclosure of the constituent ingredients of WACI, whereas my co-counsel will address the second and third issue of the legality of the nationwide ban on WACI and the liability of hypoxia in the public health crisis. Unless I can assist the bench with a summary of facts or jurisdiction, the council seeks permission to proceed with the arguments for the first issue.
Yeah, how have you come to the Supreme Court?
Your Lordships, our jurisdiction lies upon Article 136 of the Constitution of Virginia under special leave to appeal.
Is there an order? Is there an order of the Consumer Forum?
Your Lordship, the factual matrix is silent on the matter. However,
no. Is there an order that you are challenging?
No, Your Lordships.
Then how can you come to the Supreme Court?
Your Lordships, our jurisdiction lies on the fact that Article 136 of the Supreme Court gives us the jurisdiction in any matter, which would include civil matters, as in this case. Thirdly, it is contended that it is special.
Is there any judgment to support that proposition when there's no judgment of the lower court? Can you come to the Supreme Court? How can you come to the Supreme Court?
Your Lordship, due to the silence of the factual matrix, regardless of whether the judgment is final or intermediate, we seek appeal before the Supreme Court today.
Okay, next point. I am against you on this. Next point.
Indeed, Your Lordships. Proceeding to the first sub-issue, the respondent is in flagrant violation of the existing packaging and labeling regulations. To this, the Council relies on two legislations. Firstly, Regulation 5, Subsection 2 of the Food Safety Standards Labeling and Display Regulations, which declares that except for single ingredient foods, which in this case WAGI is not, a list of ingredients shall be labeled. In addition, Section 23 of the Food Safety and Standards Act is relied upon, which holds that every food business operator shall ensure that the packaging of food does not mislead consumers. We also cite the case of Ramgoa Rakshak versus Union of India, which we have cited under citations 30 and 32 of our applicant's memorial. The court held that it is imperative for the respondents to ensure the utmost of transparency in disclosing all of the constituent elements involved in the production of any food items in order to uphold the fundamental right to know of all individuals. To this, the Council seeks the court's attention to the respondent's memorial on the page number 14, paragraph number 2, where the respondents themselves state, and I quote, "Hypoxia manufactures and sells WAGI without disclosure of its ingredients in direct contravention of labeling requirements that were enforced in 2011, as well as the present regulations, both of which require unconditional disclosure of ingredients." Your Lordship, we agree on.
No. Was any permission given to Hypoxia not to disclose the ingredients by the government?
Your Lordship, the respondents also rely upon the same, which is that government exemptions were granted to Hypoxia for this particular matter. However, we intend to contend that it is not applicable in the present case on two counts. Firstly, on fact.
Have we challenged the exemption?
Indeed, Your Lordship, we are contending that exemption right now. We contend that it is not applicable.
Have we challenged the exemption?
Your Lordship, we claim that it is not applicable in this present case.
Okay, next point.
On two counts.
I have a point here.
Indeed,
in this case, the remedy is there in the food safety law for misbranding and mislabeling. So did you approach the food safety authority for this thing, or you have directly come to Supreme Court seeking this? Because there is ample remedy under the extant law of Food Safety and Standard Act, where if the label itself does not disclose the ingredient, or if the advertisements or the labeling is misleading, you could approach. Did you approach the food authority before you went to the court? I mean that's something you can clarify.
Indeed, Your Lordships. To this, we cite the clarification that we received on the 30th of August of 2022, where it was deemed that the procedural history between both of the parties has been declared irrelevant. Therefore, we proceed under the Supreme Court case that we are now contesting.
Which both parties? Sorry.
The parties of FRL and Apoxia.
FRL is a lab. I'm saying something else.
Indeed,
The Apoxia is a company. Both of you have to work under the system of food safety law. Did you?
Indeed,
okay, let's go to the next question.
The council will quickly answer that on two counts. Number one, that we indeed did ask the respondent to declare their constituent ingredients. However, they refused on account of their defense of trade secrets, which we will contend in our argumentation of issue number one. And secondly, the history of whether FSI was approached for a remedy here. The factual matrix is silent on the matter. Therefore, the council seeks permission to proceed with the rest of the argumentation.
Please.
Indeed, Your Lordships. Quickly to refute the contention relied upon by the respondents that disclosure is not required due to the government exemption granted, we contend this on two counts. Firstly, on fact, which is that exemption was granted in 2002 when Etinia was undergoing a chronic malnourishment crisis. And its duty to the public, the government granted these exceptions. We are now in 2023 when the country is undergoing a chronic obesity crisis, which is caused by the respondent, as will be substantiated in issue number 3. Therefore, these exemptions cannot be relied upon as the government owes a bigger duty to safeguard public health under Article 47 of the Constitution. Your Lordship, just a minute.
Have you made government a party to this?
Your Lordships, no, they aren't a party to the present case.
They are what?
They aren't a party to the present case.
They are not a party?
No, Your Lordships.
Are they? Why not? They are liable. They have actually allowed the things to happen. Why haven't you made them a party?
Our relief rise against Apoxia, Your Lordships.
No, but the government has granted exemption and they've allowed things to run. They are also a necessary party. Why haven't you made them a party?
Your Lordships, the council will cite a case in this particular matter. It is the case of KBT Product Private Limited versus Commercial Tax Officer, which states that if an exception given by the government is taken away by modification to an existing policy. To this, we cite a fact, which is that the exemption was given in 2002, and the existing policy, in this case being FSI, came in 2006. Therefore, if a modification to an existing policy in the grounds of public interest has been demonstrated, then the duty only remains to satisfy the modification due to the interest of public, which we in this case state that public interest has clearly been demonstrated in light of the public.
No, that is on, madam, that is on marriage. Yeah. But the government is equally liable for allowing it to happen. Why haven't you made government a party?
Your Lordship.
Okay, next point.
Indeed, Your Lordships. The council moves on to the second sub-issue, which is that the respondents cannot claim the protection of trade secrets. This is contended as the respondent's secret ingredient does not meet the definition of trade secrets. To qualify as a trade secret, 3 essentials must be met. Firstly, that the information must be confidential. Secondly, it must have economic significance. And thirdly, reasonable measures must be taken to ensure its secrecy. To this, the council calls upon the court's attention to paragraph number 5 of the Moot proposition, which tells us that rip-off companies have come incredibly close to replicating the taste of Vati. This tells us that the information is not of a confidential nature and that reasonable measures have not been undertaken to ensure its secrecy. It also tells us that despite replication, Vati maintains 40% of the market share, which clearly indicates that the taste of the product is not the purchasing factor. Rather, the brand value is of relevant economic significance to the company. Additionally, even if the respondents could meet the definition of trade secrets, they cannot enforce the same through existing legal mechanisms. In addition, even if existing legal mechanisms could be enforced, it is subject to the reasonable restriction of public health in this matter. For the same, the council will rely upon 3 cases. Firstly, the council will cite a case which discusses the balance between right to trade and right to health. In Andhra Pradesh Grain and Seed Merchants Association, the Supreme Court held that the restrictions imposed upon business in foodstuffs cannot be deemed unreasonable, as the court has to strike a balance between individual right and public evil, especially when it involves grave danger to public health. The second case that we cite discusses public interest versus proprietary interest as guaranteed by intellectual property law. Natco Pharma Limited versus Bayer Corporation holds that a right cannot be absolute and carries accompanying obligations towards the public at large. Thirdly and finally, on whether disclosure of ingredients is necessary for public health, we cite the case of ITC Limited versus Four Leaf Tobacco Venture Private Limited, where disclosure of ingredient was mandated in order to ensure safety of ingredient prior to public use. Finally, the council brings the court's attention to the respondents' written submissions on page 17 and 18, where they rely upon the doctrine of proportionality to justify the violation of packaging and labeling requirements. Your Lordships, when complete disclosure is mandated upon all food sellers across the country, the burden lies upon the respondents to prove intelligible differentia for their claimed exception for why they should not be subject to the same regulations. They have not done the same. Therefore, it is.
But that is the government has allowed it, no? The government has allowed it.
Your Lordship,
the government has allowed the exception, and you have not made the government a party. You seem to be very much close to the government in this case.
Your Lordships, the council will answer this question on 2 counts. Number 1, with respect to impleading the government in the matter, the factual matrix is silent on the same. However, clarification 7 of the.
But that is because you have not made them a party. You can't plead that.
Indeed, Your Lordships, the council calls upon the court's attention towards clarification 7 issued, which tells us the cause title of this present case, which includes applicants to be FRL and consumers and respondents to be Apoxia alone. And secondly, we cite that the government exemption was given 20 years ago when the public health crisis was entirely different, in fact, opposite to the crisis that we are facing now. And therefore, in light of their larger duty towards the public under Article 47, their positioning cannot be upheld in light of the FSI's requirement to disclose ingredients. If your Lordship is satisfied with arguments, it's substantiated for issue number 1.
Not satisfied, you continue with the argument. Not a question of satisfaction. You go on with the argument.
Indeed, Your Lordships. Due to the paucity of time, the council will quickly summarize her argumentation, which is that it is respectfully submitted that the respondent is duty bound to disclose the constituent ingredients in question. Furthermore, their assertion of safeguarding trade secrets cannot be sustained as it fails to satisfy the requisite legal criteria, which are in any case subject to the reasonable restriction of preserving public health and safety. Furthermore, it is respectfully submitted that the respondent, in a flagrant disregard for the packaging and labeling requirements, is inflicting harm upon the well-being and safety of the general public. Your Lordships, if the bench is satisfied with the arguments presented for issue number 1, the council calls upon my co-counsel to proceed with arguments for issue 2 and 3.
Go ahead.
Indeed, Your Lordships. Thank you.
Greetings to the bench. In representing the applicants, which is the Food Research Laboratory and the consumers in the present case, a roadmap of the arguments to be argued today includes the second issue on the validity of the nationwide ban imposed by the Food Safety and Standard Authority of Ethiopia, abbreviated to FSI, and the third issue claiming the respondent's liability in paying compensation in the present consumer action for the public health crisis that they caused. Before proceeding with the second issue, the council would like to delve into the jurisdictional concerns that were raised by your Lordships. One on Article 136. It is submitted that in the absence of any procedural history in the present factual matrix, we are compelled to 2 possibilities, which is 1, there was pending litigation under consumer courts or civil courts, and then we rely on clarification 1, which tells us that it was multiple civil cases clubbed together, the details and pendency of which remain undisclosed. We are therefore compelled to then rely on Article 136, which allows a special leave to appeal on any sort of final or intermediate order, decree or decision that is passed. Secondly, on the implement.
Okay, 1 minute. Since you have raised this question, where is the final or intermediate decree? Your own case is that there is no order. How can you come then?
Yes, Your Lordship.
On your own showing you can't come.
Yes, Your Lordship, but in the absence of any details to the same, and despite several clarifications, we are compelled to
but
then.
That is, you are the applicants. You have gone to the consumer forum. How can you say that there are no facts?
we are open then to the ambiguity that there may have been a final or an incomplete conclusion of the matter, and it is only Article 136.
You realize your action is ill thought of.
Your Lordship, the Council obeys to your wisdom. However, they seek to contend that on the grounds that the relief that is sought is much larger, which is of the issue of public health concern, considering the sheer scope of impact that the respondent in the present matter holds. Which then brings me to the second.
We should allow the Supreme Court to be invoked, jurisdiction of the Supreme Court to be invoked willy-nilly, without any basis.
Your Lordship, that is not the Council's contention. It is submitted that the larger cause of a childhood obesity epidemic across the country is a compelling cause, especially one done by a player in the market which holds 40% of the stake, which has been in the market for 20 years, and which admittedly...
So you could have gone to the High Court in a writ petition. Why didn't you do that? You could have also moved the National Consumer Forum through. Anyway, I think we have beaten this to the death. Let's go on to the next point.
Yes, Your Lordship. The Council then continues with the second issue, where attention of the court is drawn from the 21st page, 28th para of the memorial submitted. It is contended that FSI was correct in banning the sale of wagyu across the country as one, observance of principles of natural justice within administrative discretion is not mandatory. 2, the ban does adhere to Article 14 and 21. And 3, the ban is in compliance with the provisions of the Act of FSI. It is contended that the ban is in compliance with the provision of the FSI Act, as under Section 18G, where an accredited laboratory takes any food sample which fails to comply with the food safety requirements as a larger part of a batch, lot, or consignment, it is presumed that all of the food in that batch fails to comply with those requirements. In the present case, 2 facts are submitted. 1, all the food testing was done by FRL, which is a government accredited laboratory subject to the clarifications issued by the Moot prop. And secondly, it has government funding and is the premier health organization in the country. It is also submitted that it was not just wagyu samples that were collected across the country. It was instant ramen noodles across the country. Therefore, it is noted that when all instant noodles were examined, there was something substantial or notable that was noted, particularly in the respondent's product wagyu, that then led to this ban. It is submitted that this evidence-based scientific determination was very much in compliance with the FSI Act, as FRL is an accredited laboratory. It is then...
You are representing FRL also?
Yes, the applicants include the food research...
How can the FRL be a petitioner in this case? I don't understand this. Where are you getting it from? It's a laboratory which is independent. It can't be a litigant in the matter.
Yes, Your Lordship.
Where are you getting this from?
We are compelled by clarification 7, which tells us that there are 2 applicants, FRL and the consumers. And there's one...
FRL cannot litigate.
Food Safety Authority. The fact that where do you draw the power to ban pan-India? There's no power under the Food Safety Authority to ban pan-India. I mean, you can have food commissioner testing and banning it in states, but can you quote the section that you're saying that, you know, could empower you to ban pan-India if one batch of is found to be, you know, not as per the requirement? Because your lab is restricted in a state where you picked up the sample.
Yes, Your Lordship. First, then dealing with the nationwide ban concern, Section 34 of the FSI Act, which allows for exigent circumstances to be undertaken. Secondly, it is not just one state. Samples, reliance is then placed on paragraph 8. Samples across the country of all instant ramen noodle packets was then examined, which led to the conclusion that it was across the country that this concerning presence of the undisclosed ingredient was there. Secondly, this has previously been used in 2019 by the FSI Act in banning milk products from China due to the suspected presence of melamine. Such an exercise of powers has been done before. It is then submitted that the implement of FRL was necessary since the relief sought is similar, which is on issue 1, the disclosure of this undisclosed ingredient for a false claim of trade secrets, which is not protected under Indian law. Secondly, on the validity of the FSI ban, which is a contention of the respondents. And thirdly, and most importantly, on the public health crisis and the sheer consumer damage that they have caused for the same. Due to the shared relief sought, the 2 have been implemented. The council seeks to continue that the ban has been held in public interest as an executive action during an exigency in the interest of the larger public, may violate or may not directly comply with the principles of natural justice insofar as one, administrative discretion and the interest of fairness is considered. The same was upheld in the Supreme Court case of People's Union for Civil Liberties versus the Union of India. It is submitted that the ban was proportional and fair for the fourfold test. It must have had a legitimate goal. The legitimate goal was a public health crisis that affected its largest and most vulnerable population, being that of children. Two, it must have been a suitable means and held a rational nexus to the cause at hand. It is submitted that there is a proximate nexus between apoxia and the public health crisis that was caused. It was substantiated by scientific research as well. Thirdly, it must not be any less restrictive, which is the necessity stage, and it is submitted that in the absence of apoxia's disclosure of their ingredients, it was imperative that this product, with the kind of reach that it has with 40% market share and affecting the most vulnerable population, should be banned, therefore making it meet necessity. Hence, the ban was done in public interest due to its large consumer base. The council now seeks permission to proceed to the last.
Okay, 1 minute. Why do you say trade secret is not applicable in India? Why do you say that?
Your Lordship, on a variety of counts, the same was delved into by my co-counsel, but one, at most reliance can be placed on the TRIPS agreement. On the TRIPS agreement, Article 39 provides for trade secrets, but it is Article 39(3) itself that provides public health as an exception to the imposition of trade secrets.
You know, 1 minute. You can't rely on TRIPS agreement.
Yes.
For enforcement of, you can't rely on TRIPS agreement for enforcement in India.
Yes,
Please see the Novartis case.
Indeed.
You can only use the TRIPS agreement for interpreting the statute. We are not a civil law country where ratification of a convention will allow you to actually have a cause of action.
Indeed, Your Lordship.
What is the source of law for trade secrets, you know?
Your Lordship, firstly, it is submitted that this is not the applicant's contention. The applicant shares Your Lordship's
No. You are raising the point. Trade secrets, is it a statutory law?
No, Your Lordship. Trade secrets have not been codified. They exist within a larger framework of contract law where there exists a contract. Here, there is none. On common principles of equity, again, the same has not been done.
No, you're wrong. It's a common law principle. Okay, let's not go into that. It's common law. Trade secrets are a matter of common law, and there's no statute.
Yes, Your
Let's see what the other side say, because if you say they have not raised it, then we don't go into it.
Yes, Your Lordship. The council simply contends that where trade secrets are taken as an exemption to their mandated disclosure of the undisclosed ingredient, the same should not amount. However, the council proceeds that lastly, the action of FRL did meet principles of natural justice, and in the absence of that, it was the landmark Supreme Court case of Menaka Gandhi that upheld the validity of a post-decisional hearing in the case of non-observance of PNJ in public interest or an exigency. Therefore, this then amounts to a post-decisional hearing which can hold that the action to take a nationwide ban was imperative in the larger interest of public health. The council then seeks permission to proceed to the argument on third issue.
Well, you know what I want to say is that, sorry, Ranjit, go ahead.
Just one question. Why have you only targeted Wagi when there are other products of similar nature capturing 20% of the market? Have you done the same exercise for them also on testing and then gone after, because they're neither a party nor anything has been trained against them, but you say they are capturing 20% of the market. So it seems that you have only targeted one company that is not even, capturing the entire market. So that was one of the questions.
Indeed, Your Lordship, that is a very pertinent consideration, and that is the argument that the council relies upon to show why it was uniquely apoxia that caused the public health crisis. One, the sheer expanse of consumption that apoxia holds. Whereas apoxia uniquely holds 40% of the market share, the other competitors put together hold only 20%. Secondly, over time, and it is submitted that there is independent research and research by FRL that shows that it is sustained consumption over time that led to this crisis. It is submitted that Wagi entered the market in 2002, whereas the competitors entered the market in 2012. They have held double the amount of time, 2 decades versus 1, in the kind of impact and in the expanse of impact that they have had. It is then also submitted that let's examine the characteristics of the public health crisis that we attribute WAGI to. The largest burden of the malnutrition was children. The largest consumer base of WAGI is children. The largest burden of the obesity problem lies on children. The individuals as a vulnerable population that are most subject to harmful advertising of fast food, who are subject to nutritional misinformation due to their non-disclosure, is also children. It is therefore submitted that, and also the biggest population in the country, reliance is placed on paragraph 1. The largest population of Etenia as a demographic profile is that of children. Due to the sheer expanse and the evident causation that exists between apoxia and the public health crisis, it is submitted that particularly it is apoxia that caused this. And secondly, testing was done across the country. Reliance is placed on the second last line of the 8th paragraph, which says all instant ramen noodles were tested. It was only then that WAGI was found to be suspicious, and further testing was done along those lines. The council has now provided the consumption scale, secondly, the incidence of the largest consumer base and the biggest disease burden, and thirdly, reliable science that prove to us this causation to show why we are uniquely holding the respondent liable in the present case.
I have a query.
Yes, Your Ladyship.
How do you correlate, the consumption of WAGI and the obesity? Because you are looking at samples of a foodstuff, you are not looking at obese child and then seeing his consumption of WAGI as well as his or her lifestyle. So how do you correlate the two?
Yes, Your Ladyship, that is indeed a very pertinent consideration. The council submits 3 contributing factors. 1, the demographic profile of Etenia in the first place. 2, what we know about the product. And 3, what we know about the children. Etenia is a country that is located in Southeast Asia. World Health Organization, in its 2017 International Health Regulations, published and noticed the phenomenon of the double burden of malnutrition, which is that children and individuals in Southeast Asia specifically, who are subject and who are likely and prone to malnutrition/malnourishment, then grow up to have problems of obesity in the future. We see a very similar demographic pattern where in 2002, the government was compelled to give relaxations to a private entity and push it to 40% of the market share. And it is the same consumer base that then exhibited symptoms of chronic obesity. It is then submitted that where we have held the presence of apoxia in a demographic profile such as that of Etenia, there is a clear link. Secondly, what do we know about the product? It is the respondents themselves who, under their third issue, claim exemption under section 87(3), which tells us that it is common knowledge that fast food leads to problems of obesity. It leads to the symptoms that have been provided in the factual matrix. They also contend that this common knowledge should exempt the most vulnerable population, children, who are subject to their unfair trade practice and undisclosed nutritional misinformation, to have known better. But they use this same example to say that Mr. Ramsey cannot comment on what is supposed to be common knowledge and then claim bias on that ground. However, reverting to your...
Madam, the thing is, these are all disputed questions of fact.
Yes.
This requires a trial. This can't be decided in proceedings like this.
Indeed.
All these are complicated questions of fact which can't be decided in a summary proceeding, either writ petition or a special leave petition, unless a lower court decides these issues.
Indeed, Your Lordship. However, in the present circumstances, we are compelled, and on that count, the council would like to conclude Your Ladyship's concern that knowing what we know about Etenia, knowing the link between the largest chronic malnourishment, largest consumer base, largest part of the population, and the biggest burden of obesity, we are compelled to note that causation. The council then would like to conclude their arguments. The council seeks an extension of 1 minute.
Please continue.
Much obliged, Your Lordship. Having thus proven that causation and the evidence that exists in the obesity prevalence in Etenia, 1, amounting to a public health crisis, and secondly, the fact that this public health crisis was indeed caused by the respondent, it is submitted that the respondent should be liable to pay compensation in the present consumer case, since the Supreme Court, in a catena of decisions, including that of Consumer Education and Resource Center versus Union of India, upheld the right to health as an integral part of Article 21. It is undisputable that WAGI falls under Section 221 of the Consumer Protection Act for goods and food, and therefore the respondent falls under the ambit of both the Consumer Protection Act and the Food Safety and Standard Authority of Etinia Act. And lastly, reliance is placed on Section 9 that CPA provides upon every consumer on the right to be protected against harmful marketing and harmful product, and secondly on the right to be informed. It is this second right under Section 9 on the right to information which ties back to the first issue, that regardless of any claims made by FRL, regardless of a public health crisis, the respondent is bound to disclose the ingredients, and trade secrets does not amount to an exception. However, the respondent violated this consumer's right to be informed and their right to be protected through their non-disclosure. They supplied nutritional misinformation, provided conflicting evidence, and hid negative data in the name of profit. Note that in the respondent's written submissions from para 26 to 31, they deem it appropriate to contend that FRL does not arise as a consumer. Reliance is then placed on Section 14HB of the Consumer Protection Act that allows a party to be directed to pay a sum of money for injury suffered by a larger set of consumers that are not identifiable. Section 10A of the Consumer Protection Rules then allows this kind of compensation to be paid to the Consumer Welfare Fund. Such mechanization is then relied upon by the applicants to claim compensation for the public health damage that was caused by the respondent. To conclude, then, the Council submits the existence of the precautionary principle, a concept that has been recognized to play a key role in public health under a variety of Supreme Court judgments, and the jurisdiction over private parties that allows the respondent to be held liable for such a public health crisis. The Council concludes their arguments. It was a pleasure.
Are you claiming compensation or damages?
Compensation.
So have you calculated how it's going to be done?
No, Your Lordship, which is why reliance is placed on Section 10A of the Consumer Protection Rules, where that fund will then denote, where that fund will be the recipient, and Section 14.
But how will it be calculated? How will it be calculated? Anyway, next, no, you got your point.
So just for clarification, the Consumer Protection Act, the compensation is limited. Maximum is 10 lakh rupees. So my thing, if you're looking at compensation from CPA, what are you, again, we go back to the question asking Supreme Court for. I mean, this would have been a compensation, this would have been a remedy that you should be seeking before the National Commission about the compensation. But you are coming and reciting consumer law before the Supreme Court saying that you compensate me there, where there is a limitation on the compensation also. So
yes. Your Lordship, that is indeed a pertinent consideration, which is why the underlying impact on Article 21, the right to life and health, for the majority of the vulnerable population in the country, not only children by the very virtue of being vulnerable, but the fact that they comprise a large part of their population is something that makes it imperative for the Supreme Court's attention. Secondly, underlying articles of Article 14 in reasonableness and proportionality have also been implemented under the first and second issue, therefore bringing it beyond the realm of simply the consumer forum. And it is necessary for the Supreme Court to determine on a matter which has held the sheer quantum of national importance that this matter does. If that satisfies Your Lordship and Ladyship, the Council concludes.
Thank you.
thank you.
May it please this Honorable Court. My co-counsel and I will be appearing for the respondent manufacturer of Wagi, which is Apoxia, Your Lordships. Your Lordships, I will be addressing the issue of the obligation on the part of Apoxia to disclose its trade secrets and constituent ingredients under the Food Safety and Standards regulations of the year 2020, the labeling and display regulations, Your Lordships. My co-counsel will subsequently be taking up the issue of the validity of the ban imposed by the Food Safety and Standards Authority, and will be concluding with the third issue, which is the liability on the part of Apoxia to pay compensation to the consumers, Your Lordships. Your Lordships, to clarify about our stance on trade secrets, we humbly submit that.
No, 1 minute. Have we
Lordship.
challenged the jurisdiction of the Supreme Court to entertain the petition?
Your Lordship, we have not challenged the jurisdiction as of yet, Your Lordship,
Why
because
not?
we find that there is considerable ambiguity in the factual matrix, and we need further instructions,
That
Your
is-
Lordships. And
That is the ground for you to say there is no, the Supreme Court has no jurisdiction then. Why have
Your
you
Lordship,
challenged it?
Your Lordship, we we remain bound by the factual matrix, which suggests that your lordship, if we may argue the issue of maintainability on a subsequent date, we plead ignorance at the current stage.
All right, fair enough.
Yes, obliged, your lordship. Your lordship, regarding the reliance that we had previously placed on trade secrets to justify our non-disclosure before the matter had reached this honorable court, we would like to say that we recognize currently that trade secrets are not something that can be invoked to prevent a regulatory authority from acquiring or compelling a private party such as the respondent in this instant case to disclose information that it may require under the enactment that governs it, your lordship. Your lordship, we recognize that trade secrets are protected predominantly through judge-made law, and where there is an express statutory mandate requiring the respondent in the present case to disclose its secret ingredients, the judge-made law cannot be used to repel the statutory mandate, your lordship. Your lordship, however, we would like to state that this statutory mandate, which arises under Regulation 5, Clause 2 of the Food Safety and Standards Labeling and Display Regulations of 2020, are extremely broad and unqualified in their mandate, compelling Apoxia to disclose a list of ingredients, your lordship. Your lordship, however, we humbly submit that this regulation has to be read in tandem with the relaxation that was granted back in 2002, your lordship. And your lordship, regarding the change of regime in the year 2006, we humbly submit that the Food Safety and Standards Authority, after it came into power, has tacitly upheld this relaxation granted by the erstwhile authority, which was the Food Adulteration Authority, governed by the Food Adulteration Act of 1954, your lordship. And your lordship, this becomes evident as a matter of deduction when we see that the license granted to your lordship, initially the only labeling requirement that has been violated in the instant case, your lordship, is failure to disclose every ingredient in the list of ingredients, your lordship. Every other requirement under the labeling requirements have been followed, your lordship, which includes the mandate to affix the logo of the Food Safety and Standards Authority along with the license number, your lordship. Hence, we can conclude from this that Apoxia possesses license granted by the FSSA, your lordship. Your lordship, the license has to be...
Just one moment.
Yes, your lordship.
If you accept that the statutory mandate overrides common law, then you're bound to disclose the so-called trade secret after you've established that it is indeed a trade secret, as the other side has contained it. Then why haven't you disclosed it?
Your lordship, we humbly submit that the statutory mandate of the regulations have to be read in tandem with the exemption that was granted and upheld by the Food Safety and Standards Authority, your lordship. We submit that the relaxation was upheld due to the fact that the Food Safety and Standards Authority has continuously granted, there has been a permit issued by the Food Safety and Standards Authority. However, all that we have at present is the knowledge that the Food Safety and Standards Authority is aware of the fact that the government has been providing permits and licenses to Apoxia along the same lines, in the same vein as they had been providing these permits back in the year 2002, your lordship. And the Food Safety and Standards Authority, being aware of this, has continued to provide licenses to operate and manufacture Wagyu, your lordship.
Are you saying there's a waiver from disclosure of trade secrets by action of the respondents? Is that the argument? By implication?
There is exemption from disclosure, your lordship, due to the action of the authority, which has not been implemented in the present case, your lordship.
So why aren't you,
why
aren't you taking up the issue of jurisdiction then? That they are not able to file this petition without making everybody who's a necessary party a party to the proceedings.
On that count, your lordship, I humbly submit my erroneous statement previously, your lordship. We recognize that it is imperative to challenge jurisdiction presently, and that will be a significant ground on which we challenge it. Yes, your lordship. Your lordship.
So just one more point. What time and again you are referring to the license that you were granted under the previous law, and now that the new law has come out, so you'll obviously have to comply with the new regulations. You're saying the new regulations is very wide, and it does not kind of take its specific case. So have you challenged the new regulations?
Your lordship, in a written apologies, your lordship, to cut across. If your lordship wishes to complete your question.
Yes, I mean the new regulation is very clearly laid down. You have to list all the ingredients. So unless you have you want to guard your secret, then you have to challenge those regulations. So it's not very clear as to as to how do you wish to proceed. In one hand, where you're not even questioning the regulation, the jurisdiction, at the same time you're saying that I'm safeguarded by the trade secrets. So can we clarify that?
To humbly clarify, Your Lordship, we do not place any reliance on trade secret law per se, Your Lordship, because we do recognize that it cannot override the regulations that had been passed. However, we humbly submit that the regulations that were passed come from the same authority that has granted the relaxation, Your Lordship. And unless there is an express repeal of these relaxations, Your Lordship, and the relaxations we refer to, Your Lordship, while granted by the previous authority, have been upheld by the present authority due to its act of issuing licenses while being aware of the way in which Apoxia functions, Your Lordship. Your Lordship, this being the case, we would humbly like to submit that viewing the regulations in tandem with the relaxation that was granted, the petitioners will not be able to compel Apoxia to disclose its trade secrets or by solely relying on the regulations, Your Lordship. That would be the substance of our contention for the first issue, Your Lordship. Your Lordship, if we may additionally raise a point that has not been included in our written submissions, we felt that it would be a little wasteful of the court's time since we were highly unsure of its feasibility, but it seemed like a proposition that allows us to use trade secret jurisprudence to our advantage, Your Lordship. If Your Lordship is willing to let us continue on this point, we would be grateful to apply it to the instant case.
Let's hear your argument.
Yes, much obliged, Your Lordship. Your Lordship, in both England as well as in India, trade secrets are protected by the action of breach of confidence, Your Lordship, which has been elucidated in a number of High Court judgments in India as well as by Indian High Courts, Your Lordship. Your Lordship, this equitable action, of course, will not override any statutory mandate. However, Your Lordship, there is one jurisdiction where when an regulatory authority decides that it is imperative to compel a private party or a company, such as in the present case, to disclose its trade secrets, this compelling can be challenged on the ground that it violates the company's right to property, Your Lordship. But this is only in the United States where the right to property is a fundamental right, Your Lordship. In India and Athenia, however, Your Lordship, Article 300A of the Constitution merely formulates the right to property as a legal right, Your Lordship. Your Lordship, however, we wish to highlight that the decision of the Honorable Supreme Court in KT Plantations has recognized that property under Article 300A covers intangible property such as intellectual property, Your Lordships. However, Your Lordships, the question of whether trade secrets in themselves amount to intellectual property is disputed because the complication arises because we cannot really we cannot really say that trade secrets, if assigned to another person as property, typically can be, the possession of the original owner of the trade secrets is done away with. But Your Lordships, American jurisprudence authors such as Milgram, Your Lordships, have held that possession and title should not be conflated. And title can move from one person to another even if possession does not move. And hence trade secrets may be considered property, Your Lordships. Your Lordships,
no, we don't want to go on that road. You know your weakness on that ground.
Obliged, Your Lordship. Acknowledged, Your Lordship. Your Lordship, finally, Your Lordship, I think this would conclude our submissions for the first issue regarding the obligation to disclose. My co-counsel will be taking up the second issue, which is regarding the validity of the ban imposed by the Food Safety and Standards Authority, Your Lordship. If my co-counsel may begin.
Much obliged, Your Lordship. Coming on to the issue 2, the counsel for the respondents would like to contend that the ban levied on the sale of Wagyu by FSSAE is completely illegitimate in nature and should be struck down at the earliest, Your Lordship. This is based on 3
Have we challenged it? Have we challenged it? How can it be struck down if we did not challenge it?
Yes, Your Lordship, we are challenging the
action.
ban, Your Lordship.
Where is that? I thought it was an action of the consumers that we are dealing with.
No, Your Lordship, issue 2. Yes, Your Lordship.
Have you challenged it in? Oh.
Yes,
you
Your
have
Lordship.
Also filed a substantive action challenging the ban, is it?
No, Your Lordship. This is a writ petition, Your Lordship, under Article 32, Your Lordship.
Oh, there is a simultaneous writ petition challenging the ban.
Yes,
I
Your
right?
Lordship. Yes, Your Lordship.
Okay, go ahead.
Thank you, Your Lordship. So this challenge to the ban is brought on three limbs, Your Lordship. Firstly, that the ban is a manifest violation of the principles of natural justice, Your Lordship. Secondly, that the ban is grossly unreasonable and arbitrary in nature. And Your Lordship, thirdly, that the impugned ban is ultra vires the Parent Act, being inconsistent with the same, which is the FSS Act of 2006, Your Lordship. Coming to the first claim of the argument, Your Lordship, it is humbly submitted that FSSAE is bound by the principles of natural justice, being a statutory authority given power under the FSS Act to act prejudicially as well as judicially to the interest of its subjects, Your Lordship. Due to this, the principles of natural justice would apply to the case at hand, Your Lordship. While our respected opponents argue.
Yeah, see, 1 minute. They are
Yes, Your
saying
Lordship.
they have to be principles of natural justice, but a post-decisional hearing can be granted. That's the question you have to address. They're not disputing the application of principles of natural justice. But second question is, if there is a link between Wagi and the obesity, you first answer that question. What is your dispute on that?
Your Lordship, would Your Lordship require me to answer the first question first or the second question first, Your Lordship?
No, you answer on the post-decisional hearing. That is the argument. They're not disputing the application of principles of natural justice.
Your Lordship, going by the memo of the petitioners, they are clearly disputing that principles of natural justice are not applicable to the case at hand, Your Lordship.
No, but the learned counsel argued that this would be a post-decisional hearing. Please, that's what I heard. Isn't that correct, Ranjit?
Yes.
Yes, Your Lordship. Yes, apologies, Your Lordship. Please continue.
In fact, it was clarified that they did approach the authority and something happened. So it was kind of followed. So they've not taken that ground that whether a notice or whether a due process was followed, all that.
Your Lordship, in that respect,
they
the
are
counsel would
arguing
like
that they are arguing
yes,
that in the exigencies of the situation, a post-decisional hearing can be, doctrine can be followed. That's what I've understood.
Your Lordship, in this respect, the council would like to submit that the judgment on which they have placed reliance on, which is Maneka Gandhi, Your Lordship, for a post-decisional hearing, Your Lordship, is the Supreme Court judgment. However, Your Lordship, in this respect, we would like to submit that in the same judgment, it is expressly stated out, Your Lordship, that a post-decisional hearing should only be given in extremely exceptional cases where no other option was prevalent, Your Lordship. However, Your Lordship, in this, it is very apparent that it was our right to be given a fair hearing. It was our right to be given a hearing by the FSSAE itself, Your Lordship. The FSSAE seems to not have been approached by the opposing party, Your Lordship, and there does not seem to be any order by the FSSAE in this regard, Your Lordship.
Why should they approach? Why should they approach? It is your grievance. The principles of natural justice have not been followed. So this is your grievance. They don't have to do anything.
No, Your Lordship, this is not what the council is submitting, Your Lordship. What the council meant by approaching the FSSAE was that before levying the ban, Your Lordship, FRL and the consumers should have approached FSSAE on finding out whether Apoxia has actually violated any one of the requirements laid down under the Act or the regulations, Your Lordship. However, no such remedy was sought by the opposing party, Your Lordship. Moreover, Your Lordship, had that been done, there would have been a fair chance of hearing granted to FSSAE. Apoxia, Your Lordship, before a nationwide ban. The most draconian measure in their power was levied, Your Lordship. Moreover, Your Lordship, prejudice has been caused to us due to this, Your Lordship, that a hearing has not been granted, Your Lordship. In this case, Your Lordship, the ban is also highly unreasonable in nature, Your Lordship, because Your Lordship, there are alternative measures that could have been taken by FSSAE instead of levying this all-out nationwide ban, Your Lordship, based on a report which is manifestly biased in nature, Your Lordship. We also challenge the veracity of the report, Your Lordship. That is because yes, Your Lordship.
Counsel, in this case, when you test a product and you find some kind of impurities and something which is injurious to health, the food authority is empowered to make use of its emergency power. So these are emergency power to ban and then go into the details of building up a case. So that's why it's been used, because here the Food Safety and Standard Authority's primary goal is to give safe food for human consumption. And if they find on testing certain, like the lead in the Maggie case, they would immediately have to go ahead and impose a ban first, and then you will have to go and make out a case saying that, look, it was only some batch or something like that. So in this ground, I think they were correct in going ahead with emergency, because at the end of the public health is at the stake. So considering that, that is why the emergency powers are used.
Your Lordship, in that respect, yes, Your Lordship.
Did you seek a post-decisional hearing?
Sorry, Your Lordship?
Did you seek a hearing after the notice was issued to ban?
No, Your Lordship, not as of yet, Your Lordship.
Okay, anyway. Thank you.
Your Lordship, in respect of the in respect to the question leveled prior to the question leveled by Your Lordship, Your Lordship, it is held in this regard that, Your Lordship, emergency provisions can only be invoked when there is actually a situation of emergency, Your Lordship. However, in this case, there is no emergent conditions, Your Lordship. There is not even a proper causal link to our product, Your Lordship. The very report that they're relying on is manifestly biased, Your Lordship, and this can be proved by placing reliance on the Supreme Court judgment in A.K. Kripak, Your Lordship, where it was held that the standard for proving bias is a reasonable likelihood of bias, Your Lordship. The factual matrix seems to suggest that the FRL report was spearheaded by Mr. Ramsey himself, who is known to have been a critic of Waghi and Apoxia since way before joining FRL, Your Lordship. And it is solely based on this report that they have levied a nationwide ban, Your Lordship, not even given us a hearing before levying a nationwide ban, Your Lordship. And in this case, due to their actions, Mr. Ramsey has very well succeeded in causing prejudice to us, Your Lordship, because their ban has caused us millions of dollars of loss in revenue, brand value, good faith, and potential future investments, Your Lordship, without even giving us a chance of being heard, Your Lordship. How is this fair, Your Lordship? This is a manifest violation of Article 14 of the Constitution, Your Lordship. The right against equality of our client, Apoxia, is being squarely violated here, Your Lordship. Moreover, the order as well as the report is highly unreasonable and arbitrary, Your Lordship. It has not been released to the public. A copy of the prohibition order has not been served on us, Your Lordship. Moreover, Your Lordship, even if we were to assume that they were correct in levying this ban, given provisions under Section 34 of the FSS Act, Your Lordship, even the ban is procedurally and statutory ultra-vires, Your Lordship, because it is inconsistent with the provisions of the Parent Act. Under Section 34 of the FSS Act, subsection 1 and 3, they entail that prior to the designated officer applying for an emergency prohibition to the Commissioner of Food Safety, a notice has to be served upon the food business operator at least 1 day in advance, Your Lordship. But no such apologies, Your Lordship. Yes,
you have filed. You have not challenged the lab report. In fact, you have filed a defamation case. So if the lab report is biased and wrong, you should have challenged that report. So
Your Lordship, in challenging the ban, Your Lordship, we have made it a part of our submissions, written submissions, Your Lordship, challenging the veracity of the report also, Your Lordship.
Yes, so the case should have been on those grounds, not on the defamation that you have come out with. So right now, I think we are hearing a defamation part of this.
Your Lordship, it is humbly submitted in this respect that, Your Lordship, while we were arguing defamation earlier, Your Lordship, however, after coming to the Supreme Court, Your Lordship, we have restricted ourselves to the issues that the Supreme Court has faced, and defamation has failed to be one of those issues, Your Lordship. However, if Your Lordships wish, we would be more than happy to argue on the lines of defamation also, Your Lordship.
How is it defamatory if it is? I'm sorry.
How can you say that the report is biased? Because if they have done the collection of samples, scientifically analyzed it, on what ground? Because it was not that only Waghi packets were picked up from different places, because they picked noodles from different, rancid noodles from different parts of the country without specifically targeting a particular company. So how can you challenge that it is arbitrary or it is biased report?
Yes, Your Lordship. In that respect, Your Lordship, a reliance against is placed on the Supreme Court judgment in A.K. Kripak, Your Lordship, where it was held that the standard for establishing bias, Your Lordship, is a reasonable likelihood of bias, Your Lordship. Here, it is reasonable for us to believe that the report may have been biased because it was spearheaded by Mr. Ramsey, Your Lordship. While it is admitted that it was random samples that were taken, Your Lordship, and they singled out Waghi, Your Lordship. However, at the same time, the veracity of the report can be challenged on the grounds of it being spearheaded by Mr. Ramsey, Your Lordship, as the factual matrix seems to suggest. And Mr. Ramsey has been known to be a critic of Waghi even before. And this is reasonable grounds for us to believe that there could have been prejudice. And since it is reasonable for us to believe that there could have been prejudice, according to the Supreme Court's diktats, Your Lordship, it is laid down that as long as there is reasonable likelihood, whether actual bias was there or not is not a question that is to be entertained by the court, Your Lordship.
Just because a person is a critic of a particular product, if the critic is based on scientific reasoning, how can you say that he or she is biased?
Yes, Your Lordship, but in that respect also, Your Lordship, the council would like to submit that the report was never served to us, neither was it made public. All we are going on, Your Lordship, is the word of FRL that they conducted the research and they came to this conclusion. Your Lordship, we would also like to challenge the report on being logically and rationally inconsistent, Your Lordship. That is placing reliance on paragraph 8 of the Moot proposition, where it is explicitly stated that FRL published a report which made blockbuster claims that Waghi was over the course of time has resulted in, and I quote, all health issues faced by the nation. Firstly, Your Lordship, the report in itself is inherently vague. It is saying that our product has led to all health issues that is faced by the nation. Moreover, Your Lordship, FRL, Your Lordship, later on has asked us to disclose our secret ingredient so that the exact cause of obesity can be determined, Your Lordship. Without determining the exact cause of obesity, Your Lordship, how can the report claim that it is our product which is leading to this obesity, Your Lordship? This in itself vitiates the reasoning and the viability and the veracity of the report, Your Lordship. Not only that, but even going by the fact that there could have been personal bias, Your Lordship, this is reasonable grounds for us to believe that there could have been personal bias because he was a critic, Your Lordship, a critic since even before he joined WAG, even before he joined FRL, Your Lordship. This is more than enough reasonable grounds for us to believe that he could have prejudiced the report against our favor, Your Lordship.
You're repeating your argument. You're not answering the ladyship's question. You're repeating your argument.
Your Lordship, but this...
No, you're not answering her question. But go on to the next point.
Yes, Your Lordship. In addition to this, it is also argued that the ban is unreasonable and arbitrary in nature because no justification for the ban was provided to us, Your Lordship. The only thing that was said was that the food is unsafe and hazardous, Your Lordship. It was also made in haste, Your Lordship, because the factual matrix suggests that the proper research report and analysis by FSSAE is also underway, Your Lordship. The fact that FSSAE is conducting its own research, analysis, and report of this, Your Lordship, tends to indicate that, Your Lordship, further research and analysis in this field is required, and FSSAE is doing that, Your Lordship. But before conducting and concluding its own report, it has passed a nationwide ban, Your Lordship, such a draconian measure based on mere allegations, Your Lordship. Moreover, Your Lordship, the reason there were no reasons given to us, Your Lordship. It was simply said that it is unsafe and hazardous without giving us any justification, Your Lordship. Therefore, Your Lordship, with this, we would like to conclude our submissions for issue 2, Your Lordship, and would like to move on to issue 3.
Please continue.
Before beginning issue 3, Your Lordship, the council would request if the bench could give certain extended time for quickly summarizing our submissions for issue 3, Your Lordship.
You start, we'll see whether we need to.
Yes, Your Lordship. So, Your Lordship, it is contended for issue 3 that Apoxia is not liable to pay compensation to the applicants in the consumer action lawsuit, Your Lordship. This primarily rests on the grounds that, Your Lordship, the procedure for testing of alleged defective goods as mentioned under the Consumer Protection Act have not been followed, Your Lordship. As enlisted under Section 38, subsection 2, clauses C to G of the Consumer Protection Act, Your Lordship. Your Lordship, it is imperative for us to deduce that a complaint to the NCDRC was made by the complainants, Your Lordship. And if such a complaint is made, Your Lordship, Section 38 mandates that proper testing has to be conducted, Your Lordship. However, in the instant case, there is a it is humbly submitted that Section 38, subsection 2, clause C of the CPA, which requires samples to be taken of the alleged defective goods, which are to be sealed and authenticated by the district commissioner, has not been followed in the instant case, as samples were chosen by FRL without direction of the district commission, Your Lordship. Due to this, Your Lordship, under the Consumer Protection Act, the proper guidelines for testing and labeling, Your Lordship, have not been followed, Your Lordship. Moreover, it is also held that the exception under Section 87, subsection 3 of the Consumer Protection Act can be availed by Apoxia, Your Lordship, as it was.
Mr. Counsel,
yes, Your Lordship.
The Consumer Protection Act is in addition to and not in derogation of the main law, which is the Food Safety Act. In this case, the procedure have been followed under the food safety law. The directions have been issued there. The samples have been collected. Therefore, the tests have been given. The reports have been given to the authority, and the authority has taken action. So CPA can only come in if there is lack of any testing or there is no testing at all. Here, the Parent Act there already has done that, and Consumer Protection Act is an additional law. It's not a law which can conflict. So in this situation, I think the due process has been followed under the parent law, which is the Food Safety Act.
Your Lordship, the council accepts your assertion, Your Lordship. However, Your Lordship, in this respect, the council would also like to beg to differ and contend that, Your Lordship, in this case, the CPA would be paramount, Your Lordship, because we are talking about a consumer action lawsuit, Your Lordship, which can only be brought under the Consumer Protection Act, Your Lordship. And for that to be brought, Your Lordship, the procedure laid down under the Consumer Protection Act has to be followed, Your Lordship. Not in addition, Your Lordship, but solely for them to claim compensation under the Consumer Protection Act, Your Lordship, because the relief is claimed under the Consumer Protection Act, Your Lordship.
Okay, go on.
Yes, Your Lordship. Moving forward, it is also submitted in this behalf that Apoxia is liable to claim exception under Section 87, subsection 3 of the Consumer Protection Act, which provides that a product manufacturer, in case of a product liability action, where a danger is associated with the product, is obvious or common knowledge to the user or consumer of the product, the product manufacturer will not be liable due to their failure to warn or instruct about the said danger. Your Lordship, in this respect, the council would like to submit that while the humble opposition has held that this would not be applicable because the majority of the consumers are children. However, Your Lordship, this argument is logically flawed, Your Lordship, because come what may, it is something that it is highly presumptuous of them to assume that it is only children who are going and buying the product, Your Lordship. It can be very easily assumed on this basis on our end, or also, Your Lordship, that it was their parents who went to the supermarket and bought the product and get the warning, Your Lordship.
Mr. Counsel, how will they know when it's a trade secret? How will they know anything about it? Because the product which you are using, the ingredient, is a matter of trade secret according to you. How will anybody know?
Your Lordship, but Your Lordship,
it's a self-destructive argument.
Your Lordship, your assertion is highly appreciated. However, Your Lordship, in this respect, it would also be imperative to contend, Your Lordship, that, Your Lordship, in this case, Your Lordship, what has happened is it is only alleged that it is our product that is causing obesity, Your Lordship. It is not alleged
that they knew. No, please stick to your argument that they knew, so they can't complain. But you yourself said there's a trade secret. How can this argument be open to you? I think
Your
you should go
Lordship,
to the next point.
Your Lordship, while that is appreciated,
how-
I would also request Your Lordship to kindly let the Council complete the argument, as the Council believes that it would answer Your Lordship's contention, Your Lordship.
Okay, answer, but I think you're way over time. Eh?
Your Lordship, just before concluding, Your Lordship, the Council would simply like to hold that it is not the secret ingredient itself that has been conclusively linked to causing obesity, Your Lordship. It is just that consumption of Wagyu, Your Lordship, is leading to obesity as per the FRL report, Your Lordship. And it is common knowledge, Your Lordship, that overconsumption of any sort of fast food will lead to obesity, Your Lordship, over time. Therefore, Your Lordship, we are liable to take this exemption, Your Lordship, under 87 subsection 3, and are not liable to pay compensation, Your Lordship, in the product action suit that has been leveled against Your Lordship. With that, yes, Your Lordship.
If that is your argument, you're liable anyway, because you're saying any consumption of any fast food will actually cause obesity. Then you're liable. Anyway,
Your Lordship,
you're
saying
finished.
overconsumption, Your Lordship. Overconsumption, Your Lordship. That is like
You
saying
have to
smoking
demonstrate
cigarettes
that.
daily will lead to cancer.
How can children be over-consuming? Please understand, how can children be over-consuming? They can't eat more than a particular amount.
No, Your
I think
Lordship,
we
but
have heard
the
you now.
factual matrix in this respect seems to suggest that there has been sustained consumption, and that Wagyu has been a major player in the market, 40%, Your Lordship, and that it is present in every household. If the children do not live a proactive and healthy lifestyle and continue to eat instant noodles, it is very common knowledge, Your Lordship, that it will lead to obesity. Your
All
Lordship.
this is a matter of trial. That's why a special leave petition is not the jurisdiction.
So,
I think we stop now.
Yeah.
Yes, Your Lordship.
Is there a disclaimer on your label saying that with this much noodle you need to do so much of exercise? I mean,
no, Your Lordship, but that again comes to common reason and knowledge, Your Lordship. That is common sense, Your Lordship. That is like
I think you made your
eating
case.
a burger.
Let's
Yes, Your Lordship.
Yeah, you made your case. Let's
Thank you, Your Lordship. With that, the Council for the respondents would like to conclude their arguments and would like to pray before this honorable court that Apoxia be held not liable to disclose their trade secret. Secondly, that the Food Safety and Standard Authority's ban on the sale of Wagyu be levied, as it is ultra vires the Food Safety and Standards Act of 2006, unreasonable, arbitrary, and a violation of Article 14 of the Constitution of Ethiopia, Your Lordship. And thirdly, that Apoxia is not liable to pay compensation to the consumer action lawsuit. With that, the Council for the respondents would like to rest their case and pray this honorable court to pass any order they deem fit in the interests of justice, equity, and conscience, Your Lordship.
Thank you.
This is the counsel for the applicant to be presenting the rebuttals. However, the counsel seeks just a moment time. Proceeding now. Your Lordships, the matters before us are threefold. One, on whether there was violation of trade secrets, whether subsequently there should have been disclosure. Two, was the nationwide ban correct? And three, is there a public health crisis? Did Apoxia cause it, and should they pay it? Admittedly, jurisdiction is not an issue in the present matter, and the applicants are bound by the limited factual matrix that we have. On those grounds, jurisdiction is sought under Article 136, but applicants fully welcome any such contestation of jurisdiction by respondents in a subsequent hearing. However, in the matter present before us today, what do we have on issue one? Trade secrets. It is contended that although the issue itself begs the question of trade secrets, the respondents do not contend it as an exception to their non-disclosure of the mandated packaging and labeling requirements. If they were to contend it, it is submitted that the written submissions on page 16 of the applicants are relied upon, where their undisclosed ingredient does not even constitute to a trade secret, since it does not have the commercial value that is recognized. Since they have not taken that defense, what defense have they taken? Governmental relaxation. It is submitted that the facts before us are: in 2002, the country underwent chronic malnourishment. In 2023, today, the country is undergoing chronic obesity. Much larger than any undetailed relaxations that respondents choose to invoke over here is Article 47 of the Constitution, that makes it incumbent upon the government and the state to take actions necessary to promote and safeguard public health. In light of not just a general rise in illnesses across the country due to capitalism or industrialization, it is submitted that this is specifically a public health crisis, and therefore the onus on the government as a matter of public health is much higher than the respondents over the course of 20 minutes of pleading or their written submissions have given any due weight to. They have completed pleading the third issue, but not one mention of the children who are the victims of this public health crisis was made, except to blame them and say you should know that fast food is bad for you. However, reverting to the issue at hand, it is submitted that on that count of governmental relaxation, it is very much under the ambit of the government under Article 47 to have changed the measures that are taken, and therefore those relaxations cannot be taken in derogation to the provisions of FSI. It is also submitted that the case law here is by the Supreme Court of 2017 in KBT Products versus CTO, which is where a government provides a legitimate expectation of certain actions, which is a claim that could have been made by the respondents on another day, but has not. Even that legitimate expectation can be derogated in right of public interest. Here it is to be noted that over the course of these pleadings, two important cases come to mind. Hindustan Coca-Cola versus Santosh Mittal, which was also a Supreme Court order, which mandated disclosure even when Coca-Cola claimed that this is a trade secret of ours. We rely then upon that judgment. And secondly, and more importantly, in the case of ITC Limited versus Whole Leaf Tobacco Ventures, which held that where a product holds damaging and harmful products, it is necessary and incumbent upon that seller and manufacturer to disclose the same. Here, the respondents are in two cases where they claim non-disclosure and do not take responsibility for the sheer damage that they are imposing upon the public health of the country. Therefore, they are bound to disclose that, bound to disclose the constituent ingredients, and they are in violation of packaging and labeling requirements. What then do they contest in the nationwide ban? They claim bias. What do we have on bias? They rely on the judgment of A.K. Kraipak, and it is exactly the case of A.K. Kraipak that drew a distinction between mere suspicion of bias versus real likelihood. They use the test of real likelihood, which is to say that a reasonable man given access to reasonable information should lead to the fact that there is bias, and they conflate that to say that there could be bias. That is not only misrepresentation, but also does not amount to the facts at hand. The facts at hand being the linkage between sustained consumption of fast food for 2 decades in a large and vulnerable population. The fact being only Apoxia and Para-10 claims lack of integrity on an organization that is otherwise a premier health organization, government accredited and government funded. Thirdly, they claim that children should know that fast food is bad for you. But when Mr. Ramsey makes those comments that are very much protected under fair comment and protected under interest of public, and therefore they're not defamatory since truth is a defense, Mr. Ramsey should be held liable. Children should know better. They also tell you that there is bias simply because there are no other scientific claims. World Health Organization reports have been attached to the written submission of the applicants to prove to you the link between fast food consumption, sustained, prolonged fast food consumption, and nutritional misinformation, which is something that the respondents have been liable for in their non-disclosure of the ingredient that combine to create the public health crisis and the causation and liability arising therein. Lastly, on third issue, they do not contend anything on the actual public health crisis. You do not hear about the children. You do not hear about anything on the scientific link that was caused. Their only defense then was bias, which has been sought to be addressed here. For all these reasons, the council concludes their argument that Apoxia should indeed be liable to pay compensation in this consumer action lawsuit and for the public health crisis that they very much caused. Much obliged. It was a pleasure.
Thank you. Thank you.
Oh, may please this honorable court, if I may begin with my rebuttals.
Please.
Much obliged, Your Lordship. Your Lordship, if I may raise a preliminary objection to jurisdiction at this stage, utilizing my time for rebuttals.
No, you can't. You can't. The rebuttal, you can't. Please.
Understood, Your Lordship. Your Lordship, secondly, Your Lordship, we would like to state that our reliance on Maneka, our counter to the statement made by the petitioners relying on Maneka Gandhi to justify a post-decisional hearing, we would like to state that grave prejudice has in fact been caused to the respondents on two grounds, Your Lordship. One would be a significant loss of reputation, and the other would be to throw the livelihoods of the numerous employees working under the company into jeopardy, Your Lordship. And
You
all of
can't
this
raise
has
a
been
new
done.
argument. You can't raise a new argument in rebuttal. There's a new
Acknowledged, Your
substantive
Lordship.
argument.
Obliged, acknowledge, Your Lordship. Your Lordship, other than these 2 points, Your Lordship, we would humbly like to state that the precautionary principle that the petitioners rely upon in paragraph 62, and the first point of paragraph 62, Your Lordship, we are a little confused as to how they can present to service this precautionary principle to claim compensation, Your Lordship, without the conclusive establishment of fault, Your Lordship. Your Lordship, we as our company is completely willing to provide the details of the secret ingredients to the Food Safety and Standards Authority as it continues to test the product, Your Lordship. However, Your Lordship, we would like to state that until conclusive fault has been established, the use of precautionary principles to claim compensation seems a little bizarre to us. That would be one point that we would like to raise, Your Lordship. Your Lordship, additionally, Your Lordship, regarding the vulnerability of children, Your Lordship, we would humbly like to state that the company is committed as a part of its corporate social responsibility to make sure that its products are entirely safe for the consumption of the general public. In this relevance, we have just mentioned our willingness to impart the trade secrets to the relevant regulatory authority, Your Lordship, as it performs its testing activities.
How is this CSR? This is your main corporate thing. This is your main corporate responsibility, not how is it CSR? How can you bring CSR in this?
Your Lordship,
this is your main core business.
Apologies,
you're not
Your
doing
Lordship.
it out of CSR.
We redact that statement, Your Lordship. We redact that assertion. Your Lordship, we thus conclude our rebuttals. Your Lordship, we have a few issues to bring up before this honorable court by the next hearing, and we humbly hope that we may do so with better preparation, and thank this court for its time.
Thank you. Where is the other speaker? We only have 3.
Pardon, Your Lordship.
Your colleague is not there, madam. Speaker number 1.
Your Lordship, my presence is okay.
Yeah, thank you. What is the program now? Procedure?
Thank you, judges, and thank you, team. We will now be moving the judges to their breakout room so that they can fill in their
Aditya, can we start?
Yes, ma'am. I hope I'm audible.
Yes.
Yes, ma'am.
Have you shared the results with us?
Ma'am,
Sorry,
I'm
ma'am.
just sending.
Okay.
Ma'am, I'm starting.
Okay.
All right. Good evening.
Aditya, just a second. I just wanted to know if all the teams who were participating in the finals are here. Can the teams confirm if they're here by raising hands? Okay. Okay.
Yes,
Okay.
the teams are.
All right. Please continue.
Those who are not here, how will they say that we are not here?
No, ma'am, we confirm both the teams are here.
Okay.
Yes, ma'am. So good evening and welcome, esteemed dignitaries, participants, and students to the valedictory ceremony of the third edition of NLUO-PHFI Public Health Law Moot Court Competition 2023. I am Aditya Das, convener of this year's edition of the Moot and the moderator for this session. Today we have with us Dr. Warren Burke. Today we have with us among the dignitaries Dr. Warren Burke, Senior Attorney, Office of the Legislative Council, U.S. House of Representatives. Professor Dr. Sridhar Kadam, Director, Indian Institute of Public Health Foundation of India. Our Vice Chancellor, Professor Dr. Ved Kumari, and Dr. Risika Khare, Co-Director of Center for Public Health Law. And the teams participating universities and the members of the Center for Public Health Law who have joined us. Now I request Professor Dr. Ved Kumari to kindly deliver the welcome address.
My welcome to our esteemed collaborators and certainly our Fulbright colleague, Warren and Professor Sridhar Kadam. It's been a pleasure to be having this competition for the last 3 years. And this has been over enthusiastic participation this year with 90 teams, Warren, if you did not know this so far. I've never thought that in the third year itself, there can be 90 teams participating from all over the country. I think you're all set to go international from next year. And I'm very happy to welcome the participating teams. And certainly, one of the two teams are having it a hard time now to wait for the results. One of you is certainly the other is the runners-up, but as we said, that participating itself is a winning position. And public health is an upcoming area of a lot of interest and concern with all kinds of issues of health coming, whether from pollution, from wars, from tornadoes, from natural disasters, all kinds of scenarios are there which are causing, it has become an area of major concern. And I congratulate all the participants and all the judges and all the students and our colleagues who have been involved in organization of this competition. I see very few people at this point of time, but I had noticed more than 100 people in the inauguration. But at that point of time, all the teams were here. Everybody was wanting to get going. But now I think is the time where especially the two teams in the final are dying to know the results. Without much ado, I think it's time to ask the other two colleagues to speak something and then get on to the results.
Ma'am, thank you for the inspiring words. I would like to let you know the other teams are joining us through the live streaming that is happening on our college's channel. So other teams are also watching this meet. And now I would like to take the opportunity to present the report of this year's edition of the Moot. The preparation for the third edition began in early April, and we received an overwhelming record number of 90 teams registering for the Moot. Subsequently, over the course of 4 days, we have seen some very engaging and enriching arguments. We started with our inaugural session on the morning of the 7th, and subsequently in the same evening, the preliminary rounds began and continued to the evening of the 8th September. There were 6 sets of preliminary rounds to cater to the huge number of registrations. And over the course of the day, after which the top 8 teams qualified for the quarterfinal rounds, which were held in the morning of the 9th. Through knockout rounds, 4 teams went on to the semifinals, which were held on the evening of the same day. The finals were held today, with the best 2 teams advancing. There was a wide involvement of academicians, legal counsels, practicing advocates, law firm associates, partners, sitting judges, and experts from the field of public health law who joined us as judges for the various rounds. The entire event was organized by the Center for Public Health Law, the volunteers from the student body, and assistants from the Moot Society. I'm sure this year's edition was a great value addition to the participating universities and to the area of public health law as well. Subsequently, I would like to invite Dr. Warren Burke to address the gathering. Sir.
Thank you, Aditya. It's so good to see you again. It's so, I was there in January and February, and it's so nice to see some familiar faces. I would like to thank NLUO's Center for Public Health Law for inviting me to this ceremony and for giving me the opportunity to make these remarks. I'm especially happy about speaking with all the students, the competitors in this competition, because of course, you are the next generation of public health attorneys in India. So you ever think, what a great time to be alive? Consider this. In 1920, the average life expectancy in India was 21 years old. Now, granted, that was following the Spanish flu pandemic, so it had dipped down maybe 2-3 years, but still. After 1920, what you saw was a dramatic rise in life expectancy. 50 years later, by 1970, it had risen to 46 years old. And 100 years later, 2020, it had risen to 69 years old. I mean, think about that. A baby born in India in 1920 would have an average life expectancy of 21 years old, whereas a baby born in India in 2020 would have an average life expectancy of 69 years. And these are not just numbers, these are real people. And India is not alone in this trend. We saw a similar trend all across the globe, across the 20th century. In the United States, my country, we saw a rise in lifespan, life expectancy of about 25 years. So what was driving this dramatic and wonderful trend? Of course, the answer is public health, right? But what specifically, if we dig down to see what does that mean? Well, I'm glad to say that the U.S. Centers for Disease Control and Prevention has provided us with a list. And who doesn't love a good list? I know I'm a sucker for a good list. The list is U.S. specific, but still I think it can be extrapolated to any other country in the globe. It's a list of the top 10 public health achievements across the 20th century. As I read through them, maybe you can think, what do these achievements have in common? Here they are. Number 10, fluoridation of drinking water. Number 9, healthier mothers and babies. Number 8, recognition of tobacco use as a health hazard. Number 7, family planning. Number 6, decline in death from coronary heart disease and stroke. Number 5, control of infectious diseases. Number 4, motor vehicle safety. Number 3, safer and healthier foods. Number 2, safer workplaces. And number 1, can you guess it? Following the COVID, based on your experience in the COVID pandemic, number 1 is vaccination. Now, what do all these great public health achievements have in common? Here's an answer you might not have thought of. None of these achievements, none, would have been possible without law and lawyers. In each case, the law played an essential role in bringing about the achievements. I mean, think about it. You couldn't fluoridate a community's drinking water system without the active involvement of government and law, much less disinfect community drinking water through the inclusion of chlorine. We saw that over the course of the 20th century. In the early 1900s, we had a lot of people dying from food contaminants, contaminated drugs. Safety standards were imposed. Who drafted those standards? Who imposed them? Who enforced them? Lawyers, right? When motor vehicles rose and people started dying in increasing alarming numbers from motor vehicle crashes, what happened? We imposed vehicle safety standards, things like seatbelt requirements. And who did that? Who drafted those? Who imposed and enforced those? Lawyers, right? And this isn't even to get into issues like disease surveillance, vaccine campaigns. I'm sure you can think of many other examples. And in each case, it's easy to think about, well, how did the law apply to bringing about those achievements? I love the example in today's in the Moot Court competition of obesity, because yes, that does tend to be a very challenging and evolving public health concern across the planet. It's no small irony that countries, including India, are grappling with both food insecurity at the same time as they are also grappling with obesity as a public health challenge. Confronting this issue is going to require working through some very difficult issues of personal autonomy and privacy. And you're not going to be able to do that without, guess who? Lawyers. If the life expectancy in India is 69 today, where do you think it will go from here? Life expectancy is not a one-way street. It can go up, but guess what? It can also go down. And unfortunately, that's what we've seen in the United States in recent years. It's been heading in the wrong direction, primarily because of COVID and because of the opioid epidemic, particularly overdoses with fentanyl. In India's case, I mean, it's been really wonderful, all the progress you've made in terms of preventing and treating infectious diseases. But of course, you have issues like air pollution, which continues to worsen and is I think right now it's projected, I don't know the exact number offhand, but I recall when I was there reading something like 3 years, India losing something like 3 years of life expectancy to air pollution. So there's plenty of work to be done. And life expectancy, I mean, I'm focusing on that because it's simple, but that's only one indicator of health. There are many. And a lot of times what public health practitioners and lawyers do is they analyze these health indicators for health disparities. And you will find health disparities all over the place based on geography, based on population or subpopulation. The average life expectancy is different across India, state by state. People in urban areas tend to have a higher average life expectancy than those in rural areas. Wealthier people have a higher average life expectancy. More educated people have a higher average life expectancy. Each of these disparities create opportunities, in effect, opportunities for the public health community, assisted by the law and lawyers, to address those gaps, to help people thrive up to their full potential. Now, I'm not under any delusion that everyone who's attended this moot court competition is suddenly going to be inspired to become a public health attorney. I know I heard a rumor that many of you might have even participated more because of the IP element than the public health element. I don't know whether that's true or not. But here's what I would say. I'm going to bet that most of you, almost no matter which area of practice you engage in, are going to encounter public health law issues over the course of your careers. And that's because public health law is actually a very cross-cutting issue. I mean, if you practice housing law, you'll find yourself practicing public health law. If you practice education law, food law, certainly IP law, disaster management law, all sorts of law touches upon public health because there are so many social determinants of health. There are so many things that affect how well and how long we live. Now, I know you've all been following the G20 summit. Did you know that as part of India's presidency, you set 3 health priorities to strengthen the global health infrastructure? Here they are. First, health emergency prevention, preparedness, and response with a focus on antimicrobial resistance and the One Health framework. Second, strengthening cooperation in the pharmaceutical sector with a focus on access and availability to safe, effective, quality, and affordable medical countermeasures, meaning vaccines, therapeutics, diagnostics. Third, digital health innovations and solutions to aid universal health coverage and improve healthcare service delivery. Now, here's a question for you. What do these 3 priorities have in common? You guessed it. None of these priorities can be accomplished without the law and lawyers. So that's the vision developed by India for India and for the rest of the world. The stakes are high, and it's up to you, our next generation of public health attorneys, hopefully, to make it happen. So thank you, everyone.
Thank you so much, sir, for your wonderful words and your constant support to the center. Now I invite Professor Dr. Sridhar Kadam to address the gathering.
So thank you very much. Am I audible?
Yes, sir, you are.
Okay. Public Health Foundation of India and its local institute, Indian Institute of Public Health, Bhubaneswar, feel very honored and proud to be associated with and working with the National Law University, Odisha. We support Government of Odisha and we closely work with Government of Odisha. Like we have developed the draft state health policy for Odisha. We have developed the public health cadre. We are a member of that committee. We are also supporting Government of Odisha on developing public health management cadre. So we are closely working with Government of Odisha, and recent update I want to share with you. Even Professor Ved Kumar Madam is also there. So it's going on since long, but now the Odisha State Health University has become the reality. And the just day before yesterday, we developed a draft note. Government of Odisha wants to have a comprehensive public health act. Like there are some 5-6 states having such acts. So we want to take the inputs from National Law University Odisha about the feasibility and practicality of such public health, comprehensive public health act. For that purpose, like some officers at the state level, Director of Public Health, Director of Health Services, they had a meeting. So we will also develop bit expanded note and it will be submitted to the Health Secretary of Odisha. And then she may declare a task force on developing, and we will definitely take, I will suggest government to take the members from the National Law University as a part of task force. There will be task force, there will be working groups. So how to go ahead, because we will tell you only the health content, but the legal aspects of it. And thank that you have worked, you have so many meetings, so many participants working on different public health laws in health department, or even in public health organization like us. We may not have the whole list of public health laws where the uh, legal aspects come into, and maintaining the dignity of the people, rights of the people, because some point of time it's a very gray area to preserve the rights of the people and their health. Sometimes we have to balance between these two, and you are the experts. So this is, I think, a good news. So we will have a separate discussion with you. We want to take your inputs on comprehensive public health acts, because in other states I'm bit reserved for that. Such acts are defined, put in place, but their implementation. So we would like to listen to you as experts on implementability of such laws. So that is one good news I wanted to share with you, and then we will jointly work together on that. So with this news, I conclude my speech. Thank you very much for giving me this opportunity.
Uh, Aditya, if I may interject, thank you, Sridhar sir. And I think I should use this platform to let everybody know that Indian Institute of Public Health is also working with us in the tobacco control project. Professor Sarit Raut from IIPH has been working with us. And we've also spoken to the Public Health Department regarding drafting of the Public Health Act earlier. And I'm sure now this is going to get a more concrete form. So I'm sure we are going to collaboratively work again. So thank you, Sridhar sir.
Thank you so much, sir. This is great news, and we are really excited for it. Now I would request Dr. Ishika Khare, co-director of Center for Public Health Law, to take over for the declaration of the results.
All right, I think we finally moved to the much awaited part of the competition, the declaration of results. So I will start. First, I will start with the declaration of results of the preliminary rounds, which the participants already know. I just want everybody else also to know about the results. So the winners of the preliminary rounds, we have 8 teams who reached the quarterfinals. After 2 days of engaging competition with 6 preliminary rounds, we had OP Jindal Global University, National Law University Jodhpur, University School of Law and Legal Studies Guru Gobind Singh IP University, Himachal Pradesh National Law University Shimla, Symbiosis Law School Pune, IILM University Gurugram, Praveen Gandhi College of Law Mumbai, and Shastra University. 8 universities moving from the preliminary rounds to the quarter rounds. For declaring the results of the quarterfinal rounds, I request Professor Dr. Ved Kumari to take over.
As you mentioned, that these are already known information to the participants, but certainly for the others like Professor Sridhar and Professor Warren, this is new information which I'd share. Out of this 4 teams which went to the quarterfinal were OP Jindal Global University, Symbiosis Law School Pune, National Law University Jodhpur, and Praveen Gandhi College of Law Mumbai. And after that, the 2 teams which went to the finals were OP Jindal Global University and Symbiosis Law School Pune.
Right. So congratulations to all the teams. We move on to the next leg of the declaration of results. I invite Professor Sridhar Kadam to kindly declare the best speaker.
Interestingly, just I think December or January, I got my PhD degree from Liverpool School of Tropical Medicine. It was an online event. So I am getting that feeling how you feel. So let me declare you said best speaker.
Yes.
Yes, sir.
And congratulations to best speaker and Best speaker is Gaurangi Pandey from Symbiosis Law School, Pune.
Congratulations, Gaurangi. Sir, may I request you to declare the result of Best Memorial?
And congratulations to IILM University, Gurugram for Best Memorial Award.
Congratulations, IILM University, Gurugram. Are they here? IILM University?
Ma'am, we are here.
Gaurangi, congratulations.
Thank you.
I think both the names are of Gaurangi. I guess Best Speaker and Best Memorial, Gaurangi.
Where is the ILM team? Anyone from that team?
Yes, I think Gaurangi Khera, is it?
No, she's from Gaurangi is from Symbiosis.
That's Gaurangi Pandey.
Acha, this is Gaurangi Khera. Sorry. Oh, okay. So we don't have the winners right now here. They do not know. So of course.
No, not yet.
Yeah,
For that, we move on to Dr. Burke.
Yeah.
Dr. Burke, you must have the results on your mail. Kindly declare the results of runners-up and winners.
Oh, I didn't realize I was reading results. Okay, in my email?
Yes.
Yes.
I have to find that. Sorry. Find the results attached. Okay. Okay, are you ready? You ready for me to announce these? Okay, here it comes. The runners up. It's OP Gentle Global University. Which naturally makes the winner Symbiosis Law School, Pune. Sorry for my mispronunciations. Congratulations, everyone.
Congratulations, guys. Can we see the participants, winners, and runners-up, everybody with their cameras on? We want to see your smiling faces. Congratulations, guys.
Where is Gaurangi Pandey?
Thank you so much. This was a wonderful opportunity for learning, and the recognition is, of course, a personal victory. Thank you so much.
I want to put an invite to Gaurangi Pandey to take one session for our MPS students to demonstrate the effective speaking.
That would be an absolute honor.
We will find a date and time for that.
So Grisha is what team?
We're from OP Jindal University.
OP Jindal. And I see this is what? Samuel. Sanjana.
Good evening, ma'am. I'm from the Symbiosis Law School Pune team as well.
Okay, so it was all women team.
Yeah.
And who is your third partner, Grisha?
We have another Gaurangi Khera is there.
Okay, so you are the three teams, 2 and 1.
No,
Okay,
no, I think they have another boy.
Yeah, so one of our teammate had to like rush back due to an emergency, so he couldn't be here for the ceremony. He had to just rush out after the rounds itself.
Okay. And
I think Gaurangi Khera is from IILM University, Gurugram for Best Memorial. Is that correct?
Yes, ma'am.
Congratulations.
Thank you so much, ma'am.
Best Memorial is one person or is a team thing?
It's actually a team effort, ma'am.
Okay. Congratulations. And best speaker, Gaurangi Pandey, of course. Well done. Congratulations, heartiest congratulations. And we look forward to seeing you again in the next round.
One more observation. In our IIPH Bhubaneswar, there are 22 students for first MPH batch, and out of 22, 18 are girls. And here I could see the girls are marching ahead here also. Good.
Now soon we will have to kind of start wondering that whether there is any discrimination against women. But they are marching ahead, but they're still marching ahead in everything. But when it comes to high positions, they don't reach up to there.
Exactly.
So they do a pretty good job. When it comes to the high positions, they're still a long way to go.
Yes. In public health also, the leaders, women leaders, there is a very few.
So, okay, great. Anything else, Rishika?
Ma'am, I just wanted to declare a formal vote of thanks.
Somebody has to propose a vote of thanks.
Yes. So actually, primarily, we started the preparation around April, and then we, released the proposition, I think June, July, and then the entire preparation to this day. I have had a great support of my core team of students at Center for Public Health. And then in the organizing process, I've largely had first year students. So in the organizing team, the volunteers, first years have done a wonderful job. And also big thanks to my core team of students who have organized such an amazing task. They've done a wonderful work, because when we were looking at 90 as a number, we kind of were panicking. We were thinking beyond even 50, we were thinking it would not be possible. We'll have to do memorial qualifiers. But then we thought that, we have not asked the students that we are going to do memorial qualifiers. So we can't, midway do that. That would be unfair. So we just thought that, we have to somehow do this. But I think it was with some smaller glitches here and there, but I think I'm sure the participants will also agree. It was well managed given the number of the sheer volume of the event. Right. And thank you to the participants. They have been so cooperative and patient throughout the 4 days, and given the number of rounds they had to participate in. Thank you, everybody, and the administrative staff, my center members, faculty members. Big thanks to you. Professor Ramin Tripathi, who is the director of the center, could not be here because actually we are looking forward to a NAC visit from Monday to Wednesday. So this is a very hectic time in the university. We are going to 10 at 8.
Rishika, just at the moment he's at the airport receiving the NAC team members.
Yes, he's at the airport receiving members from the NAC team. So everything is happening simultaneously. So big thanks to him also. And thank you to every judge who was here despite bad health, despite busy schedules on working days, and also to students who might have missed some project deadlines, some examination here and there. So thank you, and I hope this competition stays with you for as long as possible. At least the subject stays with you. Thank you for the guests who have come today. Thank you, everybody. Thank you really for making this a wonderful event. Thank you to my team. Thank you, everybody. Thank you, Warren sir. Thank you, Mariam. Thank you, Sridhar sir. Congratulations again to all the participants and winners.
Namaskar. Bye-bye.
Bye-bye. We'll send the certificates out soon. Don't worry about that.
Thank you.
Thank you.
Thank you, team.
Okay, thank you. Thank you.